Hello, everyone. This is Tom Fox back again with Mike DeBernardis for another edition of the Corruption Files. In this season two, we're taking a look at some of the more historical cases, and today we want to take up at one which was or did demonstrate the excess of the dot-com era as much as any other case, and that, of course, is Tyco. Mike, I'm going to pitch it over to you to tell us about the excesses of Tyco.
Yeah, thanks, Tom. You're exactly right. I think this really fits the bill along with our favorite stories from Enron and WorldCom and all the other stories from the boom of the 90s and then the fall of the early 2000s. We're talking about Tyco was formed in the 1960s. It was really a kind of a semiconductor type company doing R&D and I think mostly government contract for a little while. And it went public in 64 and sort of evolved over the next couple of decades into more or less a security company doing fire alarm type systems, security cameras, home alarm systems. Eventually it purchased ADP, the very well-known, at least in the US, home security system. And that it grew over the course of the 70s and 80s. And that growth was mostly based on acquisitions. And then in 1992, they appointed a new CEO, a guy by the name of Dennis Kozlowski, who supercharged that growth strategy. And so where they maybe were doing 5 to 10 deals a year, which is a lot in the 80s and 90s, it became a massive operation of growth, purchasing companies of all different sizes. Eventually growing into getting on the S&P 500 and growing to revenue of $40 billion a year. Kozlowski himself became sort of a superstar in business and a really well-known CEO, a beacon of success because Tyco was viewed as very successful. The stock was doing very well. The company was reporting increasing revenues. He became one of the highest paid CEOs in the world, making as much as $150 million a year, some years. And the reality is, most of the top brass at Tyco was getting paid a significant amount of money, including the members of the board. And because of this success, he was given sort of a wide berth in terms of what he was allowed to do. In 2001 or so, there began to be some cracks in the baton there for Mr. Kozlowski and for Tyco. And they had a little bit of a falling out with the board of directors. Part of this falling out was that in one particular deal, Mr. Kozlowski had apparently authorized a bonus, a finder's fee to a member of the board of directors of $20 million for helping introduce Tyco to a potential acquisition target. And the other members of the board of directors were not thrilled with this arrangement. But I think in reality, if you look into this, what really happened is that after a decade plus of incredible growth and stock price increases as the country hit a recession, all of a sudden didn't do it well. And so there was some animosity there. And in 2002, entirely separate from Tyco, Kozlowski was indicted in New York for sales tax evasion in connection with the purchase of some art. And when he reported this to the board, they decided to fire him. And this is when the fallout of everything started happening and some of the misconduct that was going on at Tyco started to come out because they fired him. He would have been owed a pretty large golden parachute. And so Tyco hired some lawyers, thinking that something may have been off while he was there to look into it. They did. Then authorities started looking into it. And it turns out over the course of many years, there was a lot of fraud and theft happening within the company by his CFO, a guy by the name of Mark Swartz, and even the chief legal officer. And the conduct took several forms. One of the forms was through the loan program that they had at Tyco. They actually had two loan programs. One was a key employee loan program, they nicknamed KELP. And this was intended in both in spirit and by the language of the policy to allow certain key employees to take interest-free loans from the company in order to pay taxes on stock that was vesting so that they didn't have to sell the stock. They could take an interest-free loan and pay the taxes because these guys were well paid. They had very generous stock packages. The tax burden on some of their packages were in the tens of millions of dollars a year. So this was a significant burden. And Kozlowski and Swartz took full advantage of this program, and both in legitimate and illegitimate ways. So they took their loans to pay the taxes, but took additional monies to buy all kinds of things you might want to buy with an interest-free loan. And they bought real estate with it. They bought toys. I mean, this is somewhere where the more salacious facts came out, and stuff that was really irrelevant to the conduct, but that was very fun for the press to report, like Mr. Kozlowski decorating his apartment in an apartment with a personal decorator and purchasing a $6,000 shower curtain. That was one of the stories that was floating through the press. So that in itself was not great. But then taking it a step further, they, at least according to prosecutors, and they were ultimately convicted, secretly approved large performance bonuses for themselves. And rather than taking the money, right, rather than approving those bonuses and then taking the cash, they used that to pay off these interest-free loans. So they basically wiped the slate clean. And so those loans were essentially grants. Those bonuses were done appropriately, I mean, according to their calculation, but weren't, at least according to the board of directors, ever approved by the board as they should have been. And ultimately, for those bonuses, which totaled in the tens of millions of dollars, they were, both Kozlowski and Swartz were convicted of grand larceny, just theft from the company. There's another there's another loan program and relocation program where company moved to Florida. And when it did so, it offered an interest-free or low interest loans to employees to help with relocation expenses. And here, Kozlowski, Swartz, and the chief legal officer took advantage of that too, buying very nice homes in Florida, but then also purchased properties, used it to purchase properties all around the country. I think the chief legal officer purchased properties in Park City, Utah, Puckett in New York, and other places, all with these sort of interest-free loans. And they devised a secret plan to do loan forgiveness, basically a loan forgiveness program. And if you wanted to participate in this loan forgiveness program, select people were asked or were offered this loan forgiveness. You basically had to sign an NDA and said you wouldn't discuss it with anybody outside of your family, your tax advisors, and your wealth advisors. And then they found and they directed employees to find ways to misreport these different programs in their filings. And there's some other types of misconduct as well, in terms of there's allegations of accelerated vesting of certain stock that earned them an additional, basically accelerated the stock vesting at times when the stock price was very high, so it was a profitable time. A lot of allegations of insider dealings, related party transactions that in hindsight look really bad. For instance, Tyco, for whatever reason, purchased one of Mr. Kozlowski's homes for about 3 times the market value. They used, and then again, some of the salacious stuff that was often in the press is they were using the Tyco corporate jet for all kinds of personal travel. Actually, stuff was very common, I think, in the Enron case and others that the press like point out as well. So ultimately, Kozlowski and Swartz were tried together in a Manhattan court. This case, interestingly enough, was not prosecuted by the United States government, but by local prosecutors in New York. There was a mistrial, which was actually as an interesting story, where apparently a juror, after walking out for deliberations, gave an okay sign to the defense table, and the judge ultimately declared a mistrial. They were tried again, and were ultimately convicted. Both of them sentenced to more than 8 years in prison and had to pay $130 million in restitution and another $100 million in criminal fines. So a massive scandal at the time that was, I think, really, it almost fit with the narrative of what was happening at the time, right? Because this is all happening around the same time as Enron and WorldCom, and there's this era of corporate excess and lack of internal controls. In this case, just illustrates really well.
The excess really was played up in the press, and that seemed to me, Mike, to be as big a part of the trial as a lot of the criminal activity. I know there was one journalist, or at least one author, who thought that Kozlowski either was unfairly convicted or there wasn't evidence to do it. You want to at least just acknowledge what she's tried to convey?
Yeah, and she wrote a book on it, and she's a law professor at least was in Kentucky. I think her point was this happened in a different era. He never would have been prosecuted. At least for theory, the U.S. government decided that there weren't charges to bring. That's why they didn't bring them. That the bonuses that these guys gave themselves were actually proper. They were done according to a formula, and they had earned them, even if the record keeping on it wasn't great. I mean, part of the problem, it seems, for the defense in the case was the record keeping in general at the company was an absolute mess. For a company that was a $40 billion company, it was run like a mom and pop shop. You had handwritten notes, board meetings without minutes. When minutes were kept, they were just bare bones minutes, often written before the meeting itself. And while Kozlowski and Swartz, especially for these bonuses that they gave themselves, said that they had been approved by the board, there was just no way to prove it. And the board members who testified at trial either said they couldn't remember approving it or remember not having the opportunity to approve. Certainly get the point that she's making, and I think there is something to that look, this was an opportunity for prosecutors to, let's just say at the time that this trial happened, 2005 or so, very wealthy CEOs were not popular in the US. And it was certainly a time to do that. I mean, I think when you look at all the facts here, it was clear that they were doing stuff to conceal what they were doing and taking advantage of a system that was really not sophisticated enough. And the excess was extreme. I mean, the amounts we're talking about would be big.
I dealt with some of the fallout from Tyco, but from a different perspective. In 2003, Tyco acquired a company that was engaging in bribery and corruption. Tyco didn't stop that, and so they bought themselves an FCPA violation, at least a books and records violation. And that led to, at some point, Tyco deciding they had to clean up the sales side of their house from a FCPA perspective. Tyco grew, as you said, incredibly quickly and largely organically, meaning they acquired companies. This was not internal growth. And it turns out by 05, 06, maybe 04, there were some 30,000 plus sales side third parties at Tyco, which, as for those watching this, just saw Mike shake his head. For those listening, I hope you could hear him shake his head, because that number just boggles the mind, even today in 2024. And so Tyco had to get this under control. Now, this is in the era where Excel was a revelation. And it was a revelation, but it was a revelation that you had to manually input into a computer. So that meant literally that a team of forensic types had to go through and input every third party and then risk rank those third parties. I had to do that exercise once for 5,000 vendors, and I think it took us 30 days. So I can hardly imagine what Tyco had to do, but they did it. And Tyco developed the first third party, or they called it 7 steps to third party qualification. But it was really the first process that was written down that was blessed by the DOJ and SEC as a way to think through your third party risk management process. And I'm going to read it out here because it's going to sound familiar to literally everyone in compliance. And let me shout out to Scott Moritz, who was cited in one of the major authors of this. It comes from a Compliance Week article. And the 7 steps are: number 1, business sponsor. Have a primary business contact within the third party and within Tyco. Number 2, a business justification. Why are you doing business with this third party? Number 3, a third party questionnaire. Some people want a very detailed questionnaire, literally from everyone the third party is doing business with, their business structure. Some people want less, but a third party questionnaire. Number 4, a FCPA certification. A representative from the third party signs a statement to comply with the FCPA. Number 5, a risk assessment. Based upon the questionnaire and the resulting due diligence you perform, you assess the risk of that third party in terms of where they're doing business, how they're doing business, and who they're doing business with. Number 6, written agreements, have a contract with the third party so that the commercial terms will set out the payment schedule and the work that is to be done by the third party. And then number 7, training. Train the third party on your anti-corruption program. Now, we've worked on that process a little bit over the years, but that's the basic framework that I think most companies use now. And that literally came out of the Tyco imbroglio, if I can use that word. Some good did come out from the compliance perspective, but I think you're right, Mike. This case is always going to be remembered from the most excessive CEO from an era of excessive CEOs. The shower curtain, and then the one that I remember is when they dressed up their apartment to make it appear as an ancient Rome with the gold inlaid fixtures for a birthday party. That's the other one. A lot really from this case, and I had forgotten just how much theft he had engaged with. And I guess the question I wanted to pose back, this case seems to have screamed out for more rigor in the board of directors. Did anything come about either for the individual board members or maybe a structural change that required some oversight by a board?
I think the fallout for Tyco was in many stages. I mean, unlike some of these other cases, right? Enron, WorldCom that we've been mentioning, although this is excessive and the amounts are crazy high, there was an impact to the stock price, of course, but there wasn't a huge impact to the business, at least immediately. I mean, there wasn't a restatement. There wasn't anything quite that extreme, but we saw the company sort of start to falter. And frankly, it's hard to say at this point whether that's was a result of this incident and this stuff coming out, or a result of a company that had grown through acquisitions incredibly fast, possibly too fast to actually be able to run a cohesive company. And then the fact that the economy started to go down. So the company itself started to break up before it was ultimately purchased by Johnson Controls. But there was some turnover at the board, as you might expect. And I think, to me, that might be the biggest sort of takeaway from this case, because a lot of this stuff that we're seeing is stuff that the board should have been involved in approving, at least, especially at the numbers we're talking, right? For instance, the KELP loan program, it specifically said that the loans were available for relocation expenses. Okay, if you want to give a $17 million loan to Mr. Kozlowski to purchase a home in Florida, seems high, but fine. But where's the oversight of the additional $10 million for a home in Nantucket, or additional $12 million for an apartment in New York City? And that's the type of stuff that a board, especially when it's for a CEO, should be looking at. And then, frankly, there were a lot of corporate policies that had not changed since the 60s and 70s. Simply didn't change with the company as it was growing. And I put that on the board as well. I think that's a role of a board, to be thinking about receiving updates on how are we, from a compliance perspective, addressing our company's risk. And I think when you look into this, go down deep into the weeds, you see that the board members, and essentially the reason that they weren't asking these questions is that they themselves were benefiting, I think, from the sort of very juicy system that they had going on. A lot of insider transactions going on with board members. We mentioned before the one particular finder's fee, but there were a bunch of other stuff, leasing certain equipment to the company. And so they were making a lot of money from this. And that's, as often happens, all's well and good when all's well and good. And then when something starts to go wrong, all the cards start to fall.
Well, Mike, this has been a great case for us to go back and review. Like I said, I'd forgotten a lot of the corruption that was involved, and hopefully we can still draw lessons, and boards particularly will draw lessons of their role and their obligation going forward.
Yeah, I totally agree. And it's only fair, Tom, I want to mention the professor I was talking about before is Catherine Neal, and she wrote a book, I think it was called Taming the Lion, on that. So I felt we talked about her findings. So I felt only fair to name her by name.